Okay, let's try another hypothetical, a past bar exam hypothetical. And I really need to ask you for some guidance. If you're watching these issue spotting exercises and they're helpful to you, besides subscribing and liking the video and all that usual YouTube stuff, please tell me in comments what other kinds of content would be useful to you. We are trying to provide as much to you as we can that will help with your bar prep and not increase your costs. So issue spotting essays is one thing. I can do more of these if they're helpful to you. I will probably do some crossover answers, crossover essays, but this is the last subject in its entirety that I'll be issue spotting. So give me some guidance here. What do we have on this one? Well, it's unusual in that there's no instruction at the bottom saying answer according to California and ABA authorities. But look at the two calls. What ethical issues arise at the point at which Smith first asked to meet with lawyer and later during their conversation? Well, I'm going to highlight for myself that really is like two calls embedded in one numbered call, because there are 2 points in time. The point at which Smith first asked to meet with lawyer is one time point with a set of issues, and later during their conversation is a second time point with a set of issues. That first one, the point at which Smith first asked to meet with lawyer, that has to revolve around the issue of whether a lawyer-client relationship was formed and what are the pitfalls in that first ask to meet. And then later during their conversation, I don't know what that is yet. But as I'm setting my answer up in my computer, I'm going to have a separate subhead note for each of those 2 time frames, because I don't want the reader to miss the fact that I got it. I covered the 2 time frames, and I covered them separately and thoroughly. Okay, this second call. May lawyer independently disclose the problem relating to the dumping of potentially toxic chemicals to governmental authorities? That second call is about the duty of confidentiality. And when may a lawyer disclose? So let's take a look at the law on that topic right off the bat. And of course, this is an area where California differs from the ABA. In every PRSA, the hypothetical is written around facts that include major differences between California and ABA. So let's take a look at those distinctions in confidentiality. California rules are much more stringent than the ABA. The ABA allows disclosure where California doesn't. California rule, the basic rule is there. It's the duty to maintain inviolate the confidence and at every peril to him or herself to preserve the secrets of the client. You may reveal to the extent that the lawyer reasonably believes the disclosure is necessary to prevent a criminal act that the lawyer reasonably believes is likely to result in death of or substantial bodily harm to an individual. If the lawyer discloses, he or she is required to first counsel the client to seek legal means and then tell the client your ability or decision to disclose. Note, the ABA allows disclosure for financial harm. California does not. And you need informed consent. That's the law that we're going to need to answer call 2. But what do we have in the facts? We have that lawyer is an in-house attorney employed by ChemCorp, a corporation that manufactures chemicals. So lawyer is corporate counsel, which means that lawyer's primary loyalty has to be to the corporation. Then we see that Smith is a mid-level employee whose job is to ensure that ChemCorp's activities comply with applicable governmental safety regulations. Smith is in call 1, A. and B, of course. Smith asked to meet with lawyer on a confidential basis, and they put that in quotes. This is call 1A. This is what ethical issues arise at this point when Smith asks to meet with lawyer. So I'm going to want to define the fact that as corporate counsel, lawyer represents the interests of the corporation and not so much of the individual employees. Although lawyer may represent higher level employees, they would be considered to be represented by him, not on an individual basis, in the interests of the corporation. When an employee in the corporation asks to meet with corporate counsel, then counsel has to define for them where the loyalty lies, that there is no lawyer-client relationship being formed separately between lawyer and Smith. And he has to make that clear. He or she has to make that clear to Smith so that there is no formation of a lawyer-client relationship. Because if the lawyer does not do that, then by definition, a lawyer-client relationship is formed when this individual could reasonably believe that one had formed. If lawyer doesn't counsel Smith that he represents the corporation and not Smith himself, then Smith could form a belief that a lawyer-client relationship had formed. So I'm going to want to discuss all that in call 1A and explain that if that role had not been well defined by lawyer, then lawyer would have an irreconcilable conflict if Smith tells him something that is adverse to the corporation and now his loyalty is split, which is probably what's going to happen in this hypothetical. And this is a classic fact pattern that the bar liked to give reasonably often. So now we see that at their meeting, Smith said to lawyer, I think ChemCorp might have a serious problem. Okay, we're going into call 1B here, later during their conversation. ChemCorp might have a serious problem. Look at that word might, not definite. Last year, I inspected a ChemCorp facility and discovered evidence of dumping of potentially toxic chemicals in violation of ChemCorp's internal policies and applicable governmental regulations. Okay, potentially toxic. Again, they're qualifying this. Smith is not saying, I have a smoking gun here. They're dumping stuff that's going to kill people. It's not worded that strongly at all. I told my supervisor about it, and he told me he would take care of the problem. My supervisor asked me to say nothing about the situation so they could avoid any legal hassles. I did not disclose the matter in my inspection report, despite internal policies and governmental regulations that require disclosure. So Smith is now telling him that he has violated the law. I have discovered that the dumping is continuing, and I'm very concerned about possible health threats because the dump site is located near several private residences and a river used for drinking water. Okay, you see how big this problem is. If this lawyer has not defined the role ahead of time, if Smith could reasonably believe that he has formed a lawyer-client relationship with lawyer, then lawyer would owe Smith a duty of confidentiality and loyalty, but he already owes corporation a duty of loyalty and confidentiality. And those two things would be in conflict. And so the lawyer would have to withdraw. So now, if this lawyer did clarify the role ahead of time and say, you can't meet with me in confidence because my primary duty is to the corporation. If he didn't say that, then he has a worse problem, because his duty of loyalty to the corporation is to check this out, is to check out what Smith is saying to him and notify the upper management, the president, the board, about what he discovers. But if he hasn't clarified beforehand with Smith that there can be no lawyer-client relationship between them, then he can't investigate and he can't disclose to the corporation that they are violating the law, because he then would owe that duty of confidentiality to Smith. That's just a really horrendous, irreconcilable conflict. So I think in this one you had to discuss those conflicts. You had to discuss the duty of loyalty. You had to discuss withdrawal, permissive withdrawal, mandatory withdrawal. What about call 2? May the lawyer independently disclose the problem? Well, we looked at the law regarding confidentiality, and we looked at the California exceptions, which are narrower even than the ABA. And the ABA allows the lawyer to disclose when there's imminent risk of serious bodily injury or death. The problem here is that there seems to be no imminent risk. This problem has been ongoing, and it's still going on. So yeah, it's serious, but notice it's might have a serious problem, potentially toxic chemicals. Those don't seem to me to rise to the level where the lawyer would be safe in disclosing this information, in violating confidence. And they certainly are not in California. So that would be the analysis in call 2. Now, the other issue you could try to analyze somewhere in call 1B or in call 2 would be the issue of the lawyer not being allowed to be involved in an ongoing crime, or have the lawyer's services used to perpetrate a crime. I don't think you had to cover that issue, but you could add that in here. And you could find lots more issues that could be covered here. But I've talked about the ones that I think are necessary in this hypothetical. So this is the most common kind of corporate attorney hypothetical, where some employee asks to speak to the attorney, and the danger is that a separate attorney-client relationship will have been formed, and then the interests are going to be in conflict, and there are going to be confidentiality problems and loyalty problems. That's what's going on here. That always raises the issue of the lawyer's need or ability to withdraw. Fairly classic set of issues in a corporate counsel hypothetical. And now that you've seen one, it will be easier to spot all of that in the next one you run across. And that's the goal here, isn't it? I think that I will post one more issue spot of a professional responsibility hypothetical, because if you're taking the bar in California, you really, really have to know these rules and be able to analyze these well. It's almost a certainty on a bar exam.